Welcome to VSOW. Today, we're diving deep into a stack of really compelling materials, stuff that reveals the real human cost of immigration enforcement in the United States.
hmm
Our sources expose a critical intersection, the legal mechanisms of deportation, the stories of those seeking safety, and then the profound, often hidden consequences faced by their U.S.-born citizen children.
And we have a really rich collection of sources for you today. We're synthesizing the human, the legal, and the empirical.
Oh,
So this includes firsthand accounts detailing systemic failures from the Vera Institute of Justice. We also have essential legal analysis on due process rights, enforcement trends from groups like the National Immigration Law Center, NILC, the Jelani Law Firm, and the International Rescue Committee, the IRC.
right.
And maybe the most difficult part to digest is a crucial academic study from PMC. It details the measurable psychological distress experienced by American children caught up in this whole enforcement environment.
Yeah, and our mission today is really to move past the headlines. We want to understand the mechanics of this system, not just who is being deported, but how the removal process is often, well, intentionally streamlined to bypass fundamental rights. We're going to explore what it means when this pursuit of speed and volume in enforcement leads directly to measurable emotional and even developmental damage in future generations.
Right.
So this is a deep dive into fairness, legality, and the mental health crisis among American children that, seems to be driven by the current policy environment. Okay, let's start unpacking this. We really must begin with the human dimension because the experiences shared through the Vera Institute of Justice, they just make these abstract legal concepts terrifyingly real. The core message from those seeking safety, it's consistent. They say, we are human beings. Even though we are in another country, we are human beings.
Such a basic statement, but so necessary.
Exactly. And these narratives highlight how the system, even for those following the law by, say, seeking asylum, operates to expedite removal. And it frequently bypasses rights we generally assume are fundamental.
And these accounts provide just stark, undeniable evidence of how due process is systematically circumvented. Often in those really vulnerable moments right after detention. Let's look at the experience of Reina and Anna.
Okay.
They were fleeing serious, life-threatening violence in Mexico. They were seeking asylum, which is a right protected under both U.S. and international law.
Right, that's key. They were following the process.
Exactly. But instead of being processed for protection, they were immediately imprisoned for weeks in these massive detention system jails.
And the cruelty wasn't just the confinement itself, was it? It was the mechanism used to strip their legal rights.
That's right. While they were detained, they were given papers written entirely in English and just told to sign them.
Papers they couldn't read.
Couldn't read them at all. It was only later they found out these documents were voluntary departure attestations. They had essentially waived their right to seek asylum, agreed to their own deportation.
Without understanding a word, why is it standard practice or even acceptable practice to detain asylum seekers and then present them with official legal documents they can't possibly understand?
Well, it creates this massive power imbalance, doesn't it? It relies on exhaustion, on fear. They were only rescued, because a representative from a publicly funded deportation defense program intervened.
Thank goodness for that.
Yeah, this defense program had the resources to actually audit who was being detained and where. They caught the waiver before it was too late, and that allowed Reina and Anna to finally begin the legal residency process.
And this issue of coercion, it's clearly a systemic problem. It's not just an isolated incident, is it?
No, not at all. Consider Sophia's case.
Okay.
She surrendered to U.S. Customs and Border Protection, CBP, and she was placed first in the Perrera, which translates to the dog kennel.
Oh, that's horrific phrasing.
It is. And then transferred to the Hilaras, the notoriously freezing holding cells. She was held there for 2 weeks.
2 weeks in freezing conditions.
While she was in that physically and mentally debilitating state, freezing, unable to rest properly, an officer coerced her into signing a voluntary departure attestation. When she tried to actually read the document, the officer just pointed where to sign and physically flipped the page back if she tried to move past the signature line.
So forced compliance.
She was effectively forced to sign away her rights under physical duress, without any opportunity for comprehension.
That story just underscores why having legal counsel isn't some kind of luxury. It's an absolute necessity in these situations.
Absolutely essential. It took an attorney from the New York Immigrant Family Unity Project, NYIFUP, which was the nation's first publicly funded deportation defense program, to immediately intervene.
What did they do?
They halted the expulsion and ultimately secured her asylum. That single intervention prevented a blatant miscarriage of justice, one rooted entirely in coerced consent. And we also have to look at the arbitrary physical humiliation that's sometimes imposed on those seeking refuge. Take Paul's story.
Okay.
He was an Igbo Christian, fleeing persecution for his faith in Nigeria. Seeking asylum at the border, he was, understandably, utterly astonished and terrified when he was shackled hand and foot and then flown to the Buffalo Federal Detention Facility. This was during the height of the COVID-19 pandemic, too.
Shackled like a dangerous criminal just for seeking asylum.
Yes. And he asked this powerful question of his captors. Why this humiliation?
What did they say?
The answer was chilling. They refused to remove the shackles, even for eating or using the bathroom.
That's just dehumanizing.
It treats a vulnerable asylum seeker as a maximum security threat. Paul spent 21 months detained, often fearing for his life because of reported COVID-19 cases in the facility.
21 months.
His publicly funded legal defense eventually secured his release. That intervention was literally a lifeline. It potentially saved him from the pandemic and certainly from years more of arbitrary detention.
The human toll, it clearly doesn't end when the detention facility gates close, does it? The trauma of family separation stretches across borders, across years.
That's right. Rosita's account illustrates this heartbreak perfectly. Her son was only 5 years old when his father was deported to Guatemala.
5 years old.
Their final memory together. A painful goodbye through a pane of glass at an ICE detention center.
Just devastating. And Rosita's experience, sadly, is tragically common.
Yes, the source data confirms this is a widespread systemic fracturing of families. Between 2015 and 2020 alone, the government ordered the removal of over 156,000 parents of U.S.-born children.
156,000 parents. Those are American citizens whose lives, whose emotional stability are just shattered by a policy choice.
Absolutely. Rosita is now an advocate, pushing for systemic change. She wants to mandate legal representation, arguing it's the only way to prevent this constant, heart-wrenching separation.
And what's particularly alarming, from what I read, is that enforcement agencies sometimes act as if they're above judicial authority, even after a case is legally concluded.
Yes, that's a really disturbing pattern. Take Julian's case. He was a green card holder, a lawful permanent resident. He fought his deportation case for months.
Okay.
And a judge ruled in his favor, terminated the deportation proceedings. Case closed, you'd think, right?
You'd think that.
But ICE simply refused to release him for nearly a month afterward.
On what grounds?
They claimed they were waiting to see if the government planned to appeal the judge's ruling, essentially holding him without legal grounds after his case was won.
That's a blatant disregard for a judicial order, just holding someone extra legally.
It is. Julian was confined to a cell 20 hours a day, suffering needless confinement. His publicly funded lawyer had to write directly to the judge and actively press, as the source says, the enforcement agency to finally secure his release.
So tenacious advocacy was required simply to force the government to comply with its own legal ruling.
Exactly. And it begs the question, if legal rulings can just be casually disregarded like that, how can the system claim to uphold due process at all?
The terror of separation, it's just a thread running through all these stories. Anna, you mentioned her earlier, fled gang threats in Guatemala after her poor nephew was killed.
Yes. She was detained in the desert, then separated from her young son. Her description of the detention facility is harrowing. Sleeping on concrete benches or floors, being cold, given only aluminum foil for warmth.
Aluminum foil.
But what stayed with her most profoundly, she said, was the immense sadness of hearing the other children cry in the facility.
Oh, I can only imagine.
She arrived knowing no English, very little about immigration law, desperately needed an attorney. The lawyer provided by the Long Beach Justice Fund was able to guide her through the incredibly complex asylum process and ultimately secured her protection.
And without that guidance,
She confirmed she would have been deported back to danger, no question.
Jonathan's story also drives home the sheer complexity of immigration law and the absolute reliance on legal expertise.
Absolutely. Jonathan fled El Salvador as a teenager. ICE continually pressured him to sign deportation papers, which he noted many others without lawyers did, just giving up hope. He was right on the verge of voluntary removal,
Ready to give up.
ready to give up. But here's the critical discovery, something only a lawyer likely could have made. Jonathan was actually eligible to remain under the Nicaraguan Adjustment and Central American Relief Act, NACARA, from 1997.
NACARA. I've heard of it, but it sounds incredibly specific.
It is. It's a highly specific, complex piece of legislation designed to provide legal pathways for certain Central American refugees who arrive during specific periods.
And Jonathan had never heard of it.
Never. A publicly funded attorney was the only reason he was able to claim that designation and eventually receive his green card. As Jonathan himself stated, he would have certainly been deported otherwise.
So the difference between life in the U.S. and return to danger, in his case, wasn't the merit of his claim at all. It was simply access to a lawyer who understood one very specific, decades-old statute.
Precisely.
Yeah.
It highlights the critical gap.
Okay, so transitioning from these really powerful individual stories of procedural failure, let's look at the high-level policy. What dictates who gets targeted and how the system achieves its removal quotas?
Yeah, this is fascinating because the data consistently reveals something quite different from the political rhetoric. The overwhelming majority of removal actions are driven not by high-profile criminal cases, but by status violations, essentially civil infractions.
Let's clarify the terminology first, just to be sure everyone's on the same page. Deportation is formally called removal, right? A legal process defined by the Immigration and Nationality Act, the INA, Section 237.
That's correct. The INA outlines a whole range of violations, national security threats, fraud, criminal convictions. But the reality of who actually gets removed differs dramatically from, the common narrative.
So what is the most common reason?
By far, it's violations of immigration status, particularly unlawful presence. This affects an estimated 11.7 million undocumented immigrants currently in the U.S. Unlawful presence covers civil infractions. Things like entering without inspection, maybe overstaying a visa, or violating the terms of a visa, like working on a tourist visa, for example.
So administrative violations, basically.
Right. These status violations are really the bread and butter of the enforcement system. They account for the overwhelming majority of cases.
Which means, while the enforcement rhetoric often focuses heavily on the criminal alien narrative.
Exactly. The reality is that criminal convictions are the secondary driver. They're high profile, sure, but they represent a much smaller share of overall removals compared to those status violations.
And even those criminal grounds can be quite broad, can't they?
Incredibly broad. The deportable criminal offenses include things like crimes involving moral turpitude, CIMTs, and aggravated felonies. And those terms themselves are defined very broadly under immigration law. They often include nonviolent offenses that wouldn't necessarily be considered aggravated in other legal contexts.
So despite the constant political emphasis on serious crime,
ICE's own data has repeatedly shown that most deportees have no prior criminal history whatsoever. The system is primarily focused on civil status enforcement. Volume.
And this focus on civil enforcement, it seems highly sensitive to whoever is in the executive branch, their priorities. It really illustrates the power of discretion, doesn't it, in determining who actually gets pursued and removed.
Absolutely, and we've seen radical shifts in this discretion just recently.
Right. For example, the Biden administration's 2021 guidelines, they embraced a more targeted strategy, didn't they?
Yes. They focused enforcement efforts primarily on three groups: recognized national security threats, public safety threats, meaning serious criminal offenses, and recent border crossers. Under that approach, just being undocumented alone wasn't automatically deemed a priority for arrest. It allowed agents to exercise some discretion. And this ability for the executive branch to set priorities was actually upheld by the Supreme Court in 2023 in United States v. Texas.
Okay, so there was some prioritization there, but that discretionary approach was abandoned pretty dramatically with the shift in the Trump administration's enforcement priorities.
Abandoned dramatically is right. They removed almost all prioritization. And this change is directly reflected in the numbers. As of April 2025, ICE had deported over 271,000 individuals. That marked the highest number in nearly a decade.
Whoa, let's slow down on that number. 271,000 in just a few months. That's a staggering rate of removal. How did the government accelerate things so quickly?
Well, it's a combination of mechanisms. The surge reflects intensified enforcement efforts, for one, increased daily arrest targets for ICE agents, and crucially, an expansion of procedures that actually bypass judicial review.
So when priorities are removed,
Essentially, anyone who is undocumented becomes a target. Agents are given quotas, or at least strong incentives, and they often meet those quotas by focusing on the low-hanging fruit. People identified during routine traffic stops, administrative checks, folks who are then accelerated through the system.
because it focuses on volume, not necessarily the individual circumstances.
Exactly. Agents are less concerned with the depth of ties an individual has to the U.S. or the impact on their family when the primary goal is meeting a number. And the fact that over 80% of these deportations occurred at the U.S.-Mexico border also reflects an intense concentration of resources aimed squarely at accelerating removal operations right at the point of entry or shortly after.
And one of the most effective, and I think we'd have to argue most devastating, legal mechanisms enabling this surge is the expansion of expedited removal. We need to define this really clearly because it seems like one of the biggest threats to due process right now.
It really is.
Yeah.
Expedited removal is a rapid process. It allows the government to deport someone quickly without a full hearing before an immigration judge, simply because they are believed to be undocumented.
No judge involved.
Not unless a specific exception applies. The only real legal safeguard built in is if the person states a fear of returning to their home country. That statement should trigger a screening interview to assess their potential asylum claim. But the whole process is designed purely for speed and efficiency, sacrificing judicial review and thoroughness along the way.
And the sources highlight a dramatic change that took effect January 25, 2025. Previously, expedited removal was more limited, wasn't it?
Much more limited. It could generally only be applied to people apprehended within 100 miles of the border and within 14 days of their arrival. That made it primarily a tool for initial border processing.
But the expansion changed that completely.
It transforms it into a nationwide inland enforcement tool that affects potentially millions of people. The Department of Homeland Security now plans to use it anywhere in the country, against any undocumented person who cannot prove continuous physical presence in the U.S. for 2 years prior to their arrest.
Okay, let's unpack the gravity of that. What does this mean in practice?
It means someone who maybe has lived in Chicago for 5 years, they're working, paying taxes, maybe they have U.S. citizen children, but perhaps they missed a single court date years ago or entered without inspection originally. They can now be arrested hundreds of miles away from any border and summarily deported without seeing a judge.
Wow.
It fundamentally shifts millions of long-term residents into a system where their legal rights are severely curtailed. And think about the evidence requirement now.
The 2-year proof.
Yes. Community members are now effectively required to carry proof of having lived here for 2 years, things like utility bills, rent receipts, school enrollment forms, just to avoid immediate removal without a judge even looking at their case.
That's a huge burden.
It is, and this power is even intended to be used against people who entered legally through a parole program, say Afghans, Cubans, Venezuelans, if their parole status has lapsed or is somehow challenged.
Okay, so given this new enforcement environment where due process seems to be bypassed for speed, what critical knowledge do the sources, particularly NILC, emphasize? What do community members need to know to protect themselves and their families?
The emphasis is really on asserting basic constitutional rights and preparation. First, the right to remain silent. You don't have to answer questions about your status. Second, the right to not open your door to ICE or CBP unless they present a judicial warrant signed by a judge. An administrative warrant isn't enough.
Okay, crucial distinctions.
And third, the immediate right to ask for a lawyer, to say, I want to speak to my lawyer.
And what about that 2-year rule for expedited removal?
Preparation is key there. Carry evidence of long-term residence if possible. Mail with a verifiable postmark, a signed lease agreement, school records for children, pay stubs, anything that shows you've been physically present for longer than 2 years. This evidence is really a first-line defense against the immediate threat of expedited removal.
And if someone is taken into custody and they do have a fear of returning to their home country,
that fear must be stated loudly and clearly at every opportunity to any officer who will listen. I fear returning to my country. That's the trigger phrase. It's the only mechanism that might slow down the expedited process and initiate that screening interview for asylum or other protection.
And circling back to those Vera stories.
We cannot overemphasize this enough. Do not sign any documents without consulting a lawyer. Those papers are almost certainly designed to waive rights you don't even know you possess. It's standard practice to try and get people to sign voluntary departure forms quickly.
Okay, so we've seen the human cost of lacking legal representation, the sheer volume of status-based removals. Now let's dive into the legal architecture itself. Due process, it's meant to be this constitutional guarantee for everyone in the U.S., right? Yet we're seeing multiple policy tactics actively designed to limit or even eliminate that protection, turning immigration cases into something far less fair than the American legal tradition really demands.
Absolutely. Due process is, well, it's the ultimate protection against arbitrary government action. It guarantees everyone in America, and this includes non-citizens, the right to fair treatment and legal hearings when their freedom or livelihood is at stake.
It's fundamental.
It's a fundamental cornerstone of the U.S. legal tradition. And the Supreme Court just unanimously reaffirmed this in April 2025, that this right extends to everyone, regardless of their legal status.
And we have to talk about the great writ, habeas corpus. Why is that protection so vital in this context of detention and removal?
Habeas corpus is absolutely essential because it allows individuals to challenge their detention by the government. It's basically the right to ask a court, why am I locked up?
To demand justification.
Exactly. It ensures that imprisonment isn't arbitrary or unlawful. It forces the government to actually justify the confinement before a judge. And the Supreme Court has repeatedly affirmed the non-citizen's right to challenge detention and removal through habeas corpus specifically, twice in 2025 alone.
So fair hearings are essential because the stakes are just so incredibly high. They're the only real chance to present evidence, appeal mistaken decisions, expose the kind of coercion we saw with Reina and Sophia earlier.
The stakes are astronomical.
Yeah.
There's a quote from a former immigration judge that really captures it vividly. He described the court as handling death penalty cases in a traffic court setting, but with far fewer protections.
Death penalty cases in a traffic court setting. Wow.
Meaning, the decision can literally be life or death deportation back to persecution, torture, or worse, but made in this fast-paced, often under-resourced environment without many of the safeguards you'd find, even in a minor criminal case.
Which brings us to the crisis of legal representation.
Yes, it stems from a simple, brutal reality. Unlike in criminal cases, lawyers are not provided by the government in immigration proceedings, regardless of how complex the case is or how high the stakes are. The system is adversarial, but only one side, the government, is guaranteed expert legal assistance.
And the impact of this absence, it's quantified, isn't it? It's staggering.
It is. Studies consistently show that people who manage to secure legal representation are 5 times more likely to receive the legal status or protection they are actually entitled to under the law.
5 times more likely.
5 times. We saw this in the anecdotes, right? Jonathan needed a lawyer to even know about NACARA. Reina and Anna needed a lawyer to undo that coerced waiver. Without a lawyer, non-citizens are highly likely to be deported, even if they have a perfectly valid claim to remain in the U.S.
And the vulnerability of children in this system, it's particularly acute.
It's heartbreaking. Unaccompanied children, kids who are often victims of horrific abuse or trafficking, sometimes infants and toddlers, are forced to defend their rights alone, in court, against trained government prosecutors.
A toddler representing themselves in court.
It happens. They absolutely require legal guidance to navigate the system and avoid being sent back to danger. And while federal funding for legal aid to unaccompanied children has faced repeated threats, a federal court did temporarily restore it through September 2025. But the fact that these basic protections are constantly being negotiated just highlights the systemic challenge. It's not a given.
So the erosion of due process isn't just about withholding counsel. It's also about active enforcement tactics designed specifically to impede the legal process itself. One particularly, cynical tactic seems to be these ICE arrests at courthouses.
Yes, this is a devastating strategy. Officers are arresting asylum seekers and others who are actually complying with the system, showing up for routine check-ins at immigration courthouses and arresting them right there.
What's the impact of doing that?
It immediately creates immense fear and chaos. It potentially dissuades people from attending any future proceedings. I mean, why comply with the law if compliance itself leads directly to arrest?
Right. It undermines the whole system.
It does. And crucially, arresting someone at a courthouse places them directly into detention. And once someone's detained, finding a lawyer, gathering evidence, communicating with witnesses, it all becomes exponentially more difficult, if not impossible.
And sometimes these arrests are followed by attempts to fast-track deportation.
Yes, some of these courthouse arrests are followed by attempts to shift the person into that fast-track, expedited deportation process we just discussed, which, again, eliminates the essential right to appeal to a federal judge. It slams the door shut.
We also need to explore the grave risk associated with something called third country removals. This is the practice of expelling non-citizens to a third country, one that's neither their home country nor the U.S.
Right. This practice poses a really severe threat to due process, mainly because it often denies the person proper notice or any meaningful opportunity to express a fear of persecution to U.S. authorities before they're shipped off.
Where are people being sent?
Reported destinations have included places like Costa Rica, Panama, Uzbekistan, Kosovo, Rwanda, even Libya. Sending someone to a third country essentially allows the U.S. to externalize its legal obligations under refugee law. It bypasses the safeguards designed to protect people fleeing persecution.
And the most profound risk here is something called chain refoulement. Can you explain what that means and why it's so dangerous?
Sure. Refoulement itself is the core international legal principle that prohibits returning refugees to a place where they face danger, persecution, torture, etc. Chain refoulement is the risk of being sent from that initial third country back to the home country they originally fled, back to the very danger they were trying to escape.
So the third country just sends them back home.
Potentially, yes.
Yeah.
They might not have the same legal protections or screening processes in place. We've seen instances of this, like the Guatemalan man who was mistakenly deported to Mexico first, and then Mexico promptly returned him to Guatemala, even though he already had a protection ruling in place in the U.S. He was basically passed along, like a bad check, right back into danger.
Is this being challenged legally?
Yes, litigation is ongoing. Although a recent Supreme Court order in June 2025 temporarily paused a lower court order that had prevented this practice without proper notice, effectively making these removals easier for the government to conduct again, at least for now.
Okay, so if we look at this entire landscape of due process erosion, perhaps the most profound break from American legal tradition is the recent invocation of the Alien Enemies Act, the AEA. This is a really old piece of legislation, isn't it?
Centuries old. On March 15, 2025, President Trump invoked this act. It's part of the infamous 1798 Alien and Sedition Acts. The justification given was citing an invasion by the Venezuelan gang Tren de Aragua. This act was designed explicitly for wartime.
Wartime. So what authority does the AEA grant the executive branch, and why is it considered so antithetical to modern due process?
The AEA gives the government truly extraordinary authority during declared wars or when an invasion is declared by the president to arrest and expel non-citizens from designated enemy countries. And crucially, it allows this expulsion without a hearing.
Without a hearing at all.
Correct. Its most infamous historical use, of course, was during World War II for the mass internment of Japanese Americans, an action later formally acknowledged by the U.S. government as a grave wrong taken without trial, without jury.
And its current application seems focused on specific nationalities accused of gang affiliation.
Yes. The current order targets Venezuelans, even those as young as 14, unless they are U.S. citizens or green card holders. They can be expelled without any hearing if they are merely accused of gang membership by the executive branch.
Accused, not convicted.
Exactly. The penalty of expulsion is based entirely on accusation, not on judicial review or evidence presented in court. Now, lower courts and the Supreme Court have temporarily paused removals under the AEA, but the litigation is very much ongoing.
So the core danger here.
The core danger is forcibly transporting people to a prison or a third country outside the U.S. without any immigration hearings whatsoever. It represents a fundamental and, frankly, profound abandonment of the American tradition of judicial review and due process.
Okay, let's transition now. From the legal mechanics and the personal stories to the empirical data. The PMC study you mentioned, it directly measures this hidden psychological toll that enforcement takes on U.S.-born citizen children, a group that remains legally entitled to all protections, yet is often completely overlooked in policy debates.
Exactly. This study really brings the consequences into sharp focus. It looks at what are called mixed-status families. These are families where U.S.-born citizen children live under the constant stress of having undocumented immigrant parents. The parents' precarious legal status is really the foundational source of this systemic psychological distress for the kids.
And the scale of this impact, it's not small, is it?
No, it's massive. An estimated 4 million U.S.-born citizens are currently living in mixed-status families. And over the past decade, the study notes, over 1 million U.S. citizens were directly subjected to the impact of immigration enforcement, meaning they personally experienced parental detention, deportation, or some form of family separation due to enforcement.
So even before an actual enforcement action occurs, these children are living under extreme risk factors.
Absolutely. The chronic underlying dread of arrest or deportation places them at higher risk for a whole cascade of negative outcomes. Poverty, discrimination, food insecurity, frequent relocations, and perhaps most concerningly, limited access to health care.
Why limited healthcare access?
Because parents often fear utilizing public services, even those their citizen children are legally eligible for. They worry it could somehow lead to them being reported to ICE. So the children end up living in the state of constant vigilance and fear, which the body and the mind register as ongoing trauma.
And the unique strength of this PMC study, you said, is its methodology. It didn't just rely on what parents reported.
Precisely. That's a key strength. It collected data directly from the children themselves, using validated psychological assessment tools.
So it gets the child's perspective directly.
Yes. The study sought to quantify this psychological status across 3 specific groups of citizen children aged 8 to 15, ensuring the voices of the most vulnerable were heard directly in the data.
Okay, let's look at those 3 groups the researchers compared. How did they set it up to isolate the impact of enforcement actions?
The groups were very meticulously defined. Group A consisted of children who were moved to Mexico to live with their deported parents, so they experienced deportation and relocation. Group B were children who remained in the U.S. after their parent was detained or deported, experiencing the separation but staying in their home environment. And then Group C was the critical comparison group. These were children also living in the U.S. with undocumented parents, but crucially with no family history of detention or deportation.
Yeah.
So they lived under the threat, but hadn't directly experienced the enforcement action itself.
Okay, so what did the study find when comparing these specific experiences? Were there differences between the groups?
Yes, the findings reveal distinct patterns of distress. Group B, the kids who remained in the U.S. after a parental detention or deportation, they were more likely than the comparison Group C to report attention deficit hyperactivity problems.
Interesting. So behavioral issues linked to that disruption.
It suggests a link between the disruption of family life and immediate behavioral challenges manifesting in the U.S. environment.
And what about those who moved to Mexico with the deported parent? Group A.
Group A, the children who were effectively repatriated to Mexico, they reported significantly higher emotional problems and also more negative mood physical symptoms compared to Group C. Things like sadness, worry, headaches, stomach aches.
So different kinds of distress depending on the specific outcome of enforcement.
Exactly. And conversely, Group C, the comparison group living only under the threat, reported higher freedom from anxiety and higher happiness and satisfaction than Group A, the kids moved to Mexico. This indicates that while removal might stabilize the family unit in one sense by reuniting them, the massive disruption of moving to a new country, a new environment, creates its own deep emotional distress.
Okay, so the directly affected groups, A and B, showed higher levels of depressive symptoms, behavioral issues, negative moods. But you mentioned something earlier about the comparison group, Group C. That seems like the most striking takeaway here.
It is. It's incredibly striking. Despite the differences between the groups, the study revealed a catastrophic uniformity on one key measure. All 3 subgroups, including Group C, the comparison group living under only the constant threat of parental deportability, fell within the clinical category of probable anxiety disorders. This was measured by the Scared Assessment Tool's total scores.
Wait, so even the kids whose parents hadn't been detained or deported, just living with the possibility, scored in the range for an anxiety disorder.
That's exactly right. That is a critical insight. It means that the mere existence of a harsh deportation policy, the constant ambient fear it creates, even if an enforcement action has never personally touched the family, is sufficient to inflict clinical levels of anxiety and psychological distress on U.S. citizen children. The anxiety is just baked into the daily reality of the mixed-status family structure under current policies.
That's profound. The policy itself creates the harm.
It appears so.
Yeah.
And when the researchers aggregated the data comparing all the children directly affected, Groups A and B combined, versus those not directly affected but living under the threat, Group C, the differences in clinical outcomes sharpened even further.
How so?
The directly affected children had significantly higher levels of depressive symptoms, including negative self-esteem. And they also had significantly lower levels of freedom from anxiety and happiness and satisfaction compared to the threat-only group. So the direct experience layers on additional harm, particularly depressive symptoms.
Yet, despite this really high level of trauma across the board, the study did offer one small, maybe glimmer of resilience.
It did. A small but important one. None of the 83 children in the entire sample reported suicidal ideation at the time of the study.
Okay.
This suggests that while they're clearly experiencing trauma at clinical levels, there is still a degree of psychological resilience present. And that's something policy should strive to support and foster, not break down further.
These empirical findings, they really demand a policy response that moves beyond just the immediate enforcement action itself, don't they? What implications did the researchers highlight for policymakers?
Well, the data absolutely demands that immigration policies become seriously concerned with the circumstances and the well-being of citizen children during all phases of enforcement actions. They are U.S. citizens, after all. The study specifically recommends proactive preventative planning. Before raids or detentions even happen, officials should ideally consult with local child welfare authorities and mental health professionals to determine and protect the child's best interests.
Which almost certainly means avoiding family separation whenever possible.
Exactly. And the findings clearly support a move away from unnecessary detention of parents. They strongly recommend using supervised release, things like ankle monitors, check-ins, alternatives to detention for nonviolent parents. They argue quite reasonably that these individuals generally pose very little threat to public safety.
And supervised release achieves what goal for the children?
It ensures the parent can continue to care for their children. It minimizes that devastating trauma of family separation, which the study shows leads directly to so many negative psychological outcomes for kids.
And what about for those American citizens who are moved to Mexico with deported parents?
For them, the study calls for proactive efforts by the U.S. government to ensure these citizen children receive adequate support for their health, well-being, and educational progress after relocation. This means securing their access to U.S. consulates and the services available for expatriates, not just abandoning them once they cross the border.
Okay, so let's try to synthesize all of this. The human stories, the legal shifts, the empirical data, what does it all mean when we put it together? We've seen that publicly funded legal representation acts as, well, the primary firewall. It prevents arbitrary deportation and ensures vulnerable people like Raina, Anna, Jonathan can actually assert rights they often didn't even know existed.
Absolutely critical.
But simultaneously, we've seen the rise of these aggressive legal tactics, the massive expansion of expedited removal, the invocation of the Alien Enemies Act, tools that seem actively designed to bypass due process entirely and prioritize speed and removal volume over fairness.
And if we connect this to the bigger picture, the chronic erosion of due process, the systemic failure to support immigrants seeking safety, it leads directly to measurable psychological harm. And this harm isn't just inflicted upon the individuals detained, it's demonstrably inflicted upon their U.S.-born citizen children. The distress levels recorded in that PMC study, where even children living only under the constant threat of parental deportability suffered probable anxiety disorders, that underscores how the effects of enforcement reach deep into the fabric of American society. They damage its future citizens.
Yeah, which raises a really necessary and, I think, crucial question. When policies prioritize speed, volume, and the removal of individuals who, for the most part, have primarily committed civil status violations, what is the true long-term cost being paid by American families, by the country itself?
And perhaps we can leave you, our listeners, with this final provocative thought to mull over. Given that studies like the PMC-1 demonstrate this profound, multi-generational psychological distress caused just by the threat of deportation, how should policymakers actually weigh the administrative speed and efficiency of enforcement against the unquantifiable but very real cost of developmental trauma being inflicted upon American children? Children who are, after all, the future citizens of this country.
Thank you for joining us for this very deep dive and synthesis of these complex sources today.
We really hope these insights offer you a thorough and maybe more nuanced understanding of this critical intersection of law, policy, and social reality.
If you appreciate this level of detail and analysis, please do take a moment to subscribe, like, and maybe comment with your thoughts on today's discussion. We do read them.
Thank you for listening to VSOW.